Everyone, my name is Pawan and I welcome you all towards our Art of Law YouTube channel. So guys, we have started with a new initiative of teaching you all for your upcoming All India Bar examination for completely free. And AIB exam is very crucial as part of your enrollment process of becoming an advocate. And I know for the fact, especially many Tier 2 and Tier 3 colleges, even Tier 1 law colleges, they don't teach you how to exactly crack the AIB exam with shortcuts, keynotes, simple techniques on how to use the elimination method for your AIB exam to everything. And many coaching institutions are basically getting excessive amount of looting just because of the fact that you do not know the law very well and how they are trying to make money. So AIB exam you can prepare in a very free cost without any particular expensive, and that is what we have started from our Art of Laws initiative. Make sure that you're preparing for AIB exam without any particular hustle. Please do learn it, and you'll be watching all the series of video writers starting from Constitution, IPC, CRPC, evidences, and again we'll be going to contract law, property law, and along with that specific relief act. All the aspects of AIB exam will be covering one by one. Please do watch the entire video, and this is just an intro video. I just want to tell that before you go ahead with your continuation class, please do support us. Let us know in the comments what kind of content you want more so that we can parallelly make the content again and again for your upcoming exam. I know December 22nd is a very crucial day, or whichever day you're writing your particular exam, that's very much crucial for your AIP exam. Wish you all the best. Good luck. Please do go through all our notes. We're trying to cover up from previous year question papers to everything. So once again, all the best. Now let's get started with the classes. Let's continue with the series of classes which have already been held in. Wish you all the best. Good luck.
So today we'll be dealing with our constitution continuation, because you'll be getting almost like 10 marks extra from the constitution just by knowing very well the article to the Bar Act. And on that basis, we'll be continuing for today on our All India Bar examination preparation. So I just want to tell that if you prepare AIB very well for your competitive exams also, it's going to be very easy. So on that note, we will be starting with our today's video, and that is about very important question, that is about the principle of sovereign immunity will not apply to a proceeding for award of compensation for violation of fundamental rights, in which case the Supreme Court of India held the above. So it was held in the case of Rudra Shah versus the state of Bihar. Very important question. Along with that, in Kasturlal versus state of UP, it was said that the sovereign immunity will apply. Okay, so in the principle of sovereign immunity will not apply in a proceeding for award of compensation for violation of fundamental right was mentioned in Rudra Shah case. Okay, so if you violate the fundamental right, sovereign immunity will not be provided. But however, in Kasturlal case, they said that it will be provided. So just even note down even that also. Okay, so very important question. Okay, the next question which we're going to learn for today is about the courts are flooded with large number of PIL. So it is desired for courts to filter out the frivolous petition and dismiss them with cost, in which following judgment it was held the same. Okay, so the courts are flooded with a large number of PIL. What do you mean by PIL? The public interest litigation. So normally is something which has been affecting public at large. We file this PIL. Very important. Okay, you should be knowing it without fail. So under this following four option, which is the correct answer? The correct answer was in Holico Pictures Private Limited versus the Premchand case. They said that what the courts are flooded with large number of PILs. I'll just put a red mark. Okay, large number of PILs. So it is desirable for courts to filter out frivolous petition and dismiss the cost. Whereas what happened in MC Mehta was Union of India. Do not get confused. Okay, in MC Mehta was Union of India, the Bhopal gas tragedy. It's a very famous case. And it was mentioned about this absolute liability was also emphasized over here. Both of these cases, I want to highlight that it was Justice P.N. Bhagavati who basically highlighted this about this particular case in a very well established manner. So just note down even about that also. Okay, so now we'll be dealing with 22nd question. The Supreme Court partially struck down the 97th Amendment of the Constitution of India in a landmark case of 2021. The amendment, just once again, the Supreme Court partially struck down 97th Amendment to the Constitution of India in a landmark case of 2021. The amendment deals with. So I'll just tell you this question is nowhere there in the Bar Act and it's very hard for you to figure it out. But however, the four options are given. You can parallelly try to observe it and try to learn it with the help of a few couple of things. In 97th Amendment, it was majorly about cooperative society. That basically means is about, so it was in the famous case of Union of India versus Rajendra Shah. Just write it down if you want. Union of India versus the Rajendra Shah case. Rajendra Shah SHH. Rajendra Shah case, in which it was basically held that only the state had the power to make any laws about this cooperative society. So who had powers? Only the state had powers to make laws regarding the cooperative society. But at lateral point, it was basically being struck down. And if you observe, even in our constitution, if you just quickly go to part 9, where is yes, part 9b, you will find laws, like you will find articles specifically mentioned about a cooperative society. So you just need to go very depth about it and just like understand at least the case law. That would be fine, even though if you're not understanding the entire crux of it, koi baat nahi, but if you're able to just go through it, it would be fine. So let me just go quickly to 9a 9b. Okay, yes, municipalities it's covering. Yes, the cooperative society specifically it's been covered under a part 9b. So just go through even that also. Even Article 21a also tries to emphasize over it. So just remember this particular case. That's more than enough. Union of India was Rajendra Shah in 97th Amendment. What was this particular being held about? Okay. So now the 23rd question is about in which of the following cases the Maratha reservation quota was struck down by the apex court. So now in the Maratha reservation quota was struck down by the apex court, in which of the cases it was, there are four questions given. So I know for the fact it's very hard for you to by heart all the case, but you can use the common sense, okay, common logic over here, and then if you are able to apply it away, you will be able to like ace this particular question. So Jaishri Lakshmi Rao Patil, it's basically Maratha. So this Patil is basically a Maratha name. So obviously you can remember it by the key names itself. So apart from that, there's no other way for you to by heart it. Okay. So in Maratha, reservation quota was basically been struck down in the Jaishri Lakshman Rao Patil case. So I hope you guys understood about it. The next question would be about the short title of the Constitution of India is mentioned under which article? Is it 5, 392, 393, 394? See, if you observe, look at the odd one. 5, it's there. See, it's very hard. Like, what's not very hard. You need to go to all the important articles of these 25 to figure it out. What is short title and what is not a short title. So I just tell you, if 5 is the odd one, then most of the time this is not the right answer. But if you observe in the pad 392, 393, 394, we can understand that okay, somewhere it is related. As it is part of the short title, what you can do, quickly go to a barrack and just look into 392, 393. Let's go 300, 300, 300, 300, 300, 300. Yes, it's easy itself. It's the only thing is that you just need to be very smart enough and able to figure it out what is right and what is wrong. Right. So now let me just go to 392. I'm in 330 now. Yes, about to reach. Yes, 393 speaks about the short title. The answer would be about what? It would be Article 393. All right, very simple as that. I hope it's clear for you all. Yeah, so the 25th question is about assertion. The right to education is a fundamental right. Reason is about our constitution had no provision for education before making right to education as a fundamental right. See, if you observe here, right to education as a fundamental right, it was basically being declared in the case of Unnikrishnan JP was the state of versus the state of AP. Okay, I'll just quickly write it down over here. So it'll be easy for you to write it down for your exam. Okay, Unnikrishnan JP versus the state of state of AP. Okay, it was held in this particular case that right to education is a fundamental right. I'll just put a yellow mark over here so that you can refer. And it was basically been declared under the case of Article 21 of the Constitution. Okay, Article 21 of the Constitution. Very simple as that. So I hope it's very clear for you. Now, the next important question. So let me just put so this D is the correct answer. I'll put a red mark for you also. Yes, it's clear. Secularism is one of the five constituents of the Constitution of India and has been held to be the only permissible religion in a pluralistical Indian society. In which of the cases it was decided? So if you observe in the first question itself, which we decided was about SR Bommai case, in which it was said that secularism is part of the basic structure doctrine. Okay, as part of the constitution. So that is SR Bommai case. I know it's very hard to learn all the sentence to decide what happened in the cases, but if you remember, SR Bommai was the Union of India. No matter what, any time until you're going to the grave, you should be remember. It was said about a secularism as part of the basic structure doctrine. And along with that, in this particular case, they mentioned about Article 356. You know what happened was like in Article 356, the state, all the powers of the state was vesting with the power with the central government in case if they don't practice with the element of secularism to everything. So challenging this particular decision, the the state government approached to the court stating that how is it possible that the center can take over my complete powers for the same just because we're not following the secularism. And then Supreme Court said that no, secularism, you should be following it no matter what, because it is part of the basic structure doctrine. So just remember this in a very short note. It will be very easy for you. I'm just quickly writing down this particular article. It's Article 356 also. About even Article 356 was also being decided in this particular case. Emergency where state center can take over the state. I hope it's clear for you. So now, in which case the curative petition was innovated by the Supreme Court of India. So curative petition was basically introduced in the Arupa Ashokpura versus Ashokpura case. So what happened in this case was about, in the landmark case, the Supreme Court of India innovated the concept of curative petition 2002. The case was significant because it provided a mechanism to challenge the final judgment of the Supreme Court after all the legal remedies have been exhausted. That means that after all the, for example, even the final judgment of the Supreme Court can be challenged under which petition? It can be challenged under this curative petition. Okay. So the key points about this case was about, it introduced the concept of curative petition as a last resort for litigants who believe they have the right have been denied the justice. So that was basically being highlighted over here. I'll just put I'll just change the mark over here so it'll be easy for you to learn. Okay. The petition is to be heard of the same judges who believe the original judgment. It aims to prevent miscarriage of justice in cases where review petitions have been rejected. I hope it's clear for you. Now let's move ahead with the next question, which I'm going ahead in terms of 28th one. In which of the following cases the Supreme Court struck down Section 66A of the IT Act 2000? So it is the Shreya Singhal versus Union of India case. It's a very prominent case which many of the law students actually know it. So I'll tell you what happened in the Shreya Singhal versus Union of India case. Okay, bro, it's very simple. So Shreya Singhal case, what happened? She was a law student. Okay, so she was in Maharashtra. Actually, one of the very top politician was passed away, and then there was actually complete leave in Maharashtra for almost like 2 days. Almost like 2 days. So Shreya Singhal, she went into social media and she posted a comment. Okay, she posted this, and based on that, there was a very big viral fight regarding it. So the question was like, how can she post like this? It's against the government to everything like that. So she approached the Supreme Court. Like when the case was called out, she approached the Supreme Court. She said that I can post anything because it was in violation of like it's my right in terms of posting anything on social media because it is my freedom of speech and expression under Article 19. Under Article 19 needs to be protected, and the court also said that yes, freedom of speech and expression needs to be protected. So Article 19 is really emphasized over here. So Shreya Singhal case, they emphasize over Article 19. Very simple case. So make sure that you're not living it out. So from that day onwards, Section 66A of the IT Act was basically being struck down. Now, in the case of state of Bihar versus the Kameshwar Singh is related to which of the following doctrines? So now first we'll learn which of the four doctrines first. First, the doctrine of basic structure. What do you mean by basic structure doctrine? I want you to learn all the four doctrines first. So basic structure doctrine is about, see, parliament can change everything which is there in the constitution. Okay. So I'll just put like a formula now. Parliament can change everything in the constitution except the basic structure, because what? It is an integral part of the constitution. Okay. Basic structure, but apart from that, it cannot be changed. Now, what do you mean by doctrine of eclipse? Doctrine of eclipse is nothing but any law which is violating the fundamental right, any law which is violating the fundamental right can be considered to be void. Okay, that is doctrine of eclipse. Very simple. Any law. So under Article 13, you can basically learn this. Article 13, you will be able to learn this. Now, I'll just highlight over here. This is an explanation for you so that you don't get confused. And people who have anyway bought our materials, this will be like direct access for you guys. Doctrine of pith and substances means what? See, under this, Schedule 7 and Schedule 7 of Article 246, if you observe, there's something called a state list, union list, and concurrent list. State list means what? What and all aspects mentioned in the state list, state can take the decision. Central list means what and all comes under the defense, foreign affairs, everything, what center can take up. So, and concurrent list means both center and state can take it. So that's called as doctrine of pith and substances. Now, what do you mean by doctrine of colorable legislation? For example, if state government or if central government is not able to make any law directly which is mentioned in the central list, but it is there in the state list. Okay. Now, if they do something which is apart from the particular jurisdiction, they cannot do something indirectly. For example, a state government want to do something regarding defense and foreign affairs, which they're not empowered to do. So if they're trying to bypass something and do, then they will be held caught. So this is about doctrine of colorable legislation. The answer is doctrine of culpable legislation. That is the correct answer. Now we'll be dealing with the very important 30th question. The case of Unikrishnan versus state of Andhra Pradesh deals with which of the following? It is obviously right to education. Under Article 21A, we have already dealt it in very much detail. Please do go through it. I hope it's very much clear for you. So wish you all the best. Good luck. This much is enough for today for a constitution preparation. All the best. The more you try to do MCQ, the much depth of law and constitution you'll be having clarity. Okay. So in the next video, we'll come up with further discussion. Take care. Goodbye. Wish you all the best. And if you have any comments, let me know. And if you feel like more kind of content or video I'm supposed to make, let me know for the same.
Thank you all for watching this amazing video. So we would just have a small request. Please do like the video, please do share the video and share it among your friend circle, because all the videos we're sharing over here is completely free of cost. It can really even benefit you as well as benefit us having more subscribers and more law community. So we can even support you in a very well established manner. Again, in any particular manner, please do let us know in the comments what kind of videos you want us to upload more, or how you felt about today's video, so we can improve on it and we can, parallelly increase the pace of having more videos to your supporting of your legal knowledge.